A very good evening to you all, ladies and gentlemen. I'm excited to welcome you to the 51st episode of the webinar series held in English, organized by the Seminars Committee of the BASL 2021-2022 on the topic of law relating to electronic transactions. This webinar series is conducted on the Zoom platform, and for those who have been unable to register on Zoom could also join by watching the live stream on the BASL YouTube channel. We would like to thank the Seminars Committee of the BASL, Chairman of the Seminars Committee, Mr. Rajiv Amarasuriya, Convener of the Seminars Committee, Assistant Secretary, BSL, Mr. Pasindu Silva, and the co-conveners, Mr. Pandula Vaniarachi, Mr. Oshan Udayaratna, Ms. Ann Devananda, and Ms. Nikini Mapitigama. I would also like to take this opportunity to thank the President of the BASL, Mr. Salia Piris, President Council, and the other members of the Management Committee of the BASL for all the support and guidance given to us in organizing this webinar series. Today's topic is law relating to electronic transactions, and joining us today we have the distinguished panel of experts ready to enlighten us and share their knowledge and experience. And also another special fact that I would like to add in is that we have reformatted the formation of the panel board. So we will have 3 panelists and the moderator for the day going forward in the webinars to come, so that each panelist will now have more time to share their experience and knowledge in the relevant topic. I now take this opportunity to introduce the esteemed panel and the moderator for the day. Firstly, I would like to introduce Honorable Justice K.T. Siri. He is a career judge who served Sri Lankan judiciary for more than 38 years, having a wealth of experience and expertise, particularly in the areas of commercial law and in civil litigation. Justice is the current Parliamentary Commissioner for Administration Sri Lanka, and he also serves the judiciary of Sri Lanka as a magistrate from the year of 1980 to 1988, a district judge from the year of 1988 to 2001, a judge of the High Court from the year of 2001 to 2008, a judge of the Court of Appeal from the year of 2009 to 2015, a judge of the Supreme Court from the year of 2015 to 2018 April. Justice Siri was also the Chief Magistrate of Colombo and the Principal District Judge of Colombo. In the year of 2002, Justice was appointed as the Judge of the Commercial High Court of Sri Lanka and served in that capacity until the year 2009, becoming the longest serving judge in that capacity in the Commercial High Court. Justice Siri's services were seconded by the Judicial Service Commission, which is being headed by the Chief Justice, to function as the Director, Human Rights Commission, and also as the Registrar of Companies in Sri Lanka. Honorable Justice also been a member of the panel of lecturers at the Judges Institute of Sri Lanka, and also involved in preparation of course materials to facilitate in-service training for judges. Honorable Justice is also presently holding the office of the Chairman of the Appeal Advisory Committee at the Ministry of Sports and Youth, and the function of which is to determine appeals filed challenging the decisions of the Sports Association in the country and to advise the Minister accordingly. Secondly, I would like to introduce Mr. Sunil Dibi Aberratna, attorney at law. He was enrolled as an attorney at law in the year of 1986. He holds an LLM from the Queen Mary's College of the University of London, an MBA from the Indira Gandhi National Open University, and a diploma in forensic medicine, science and toxicology from the University of Colombo. Mr. Aberratna is also a practicing attorney at law and a commercial arbitrator. He is also a visiting lecturer and an examiner in the Faculty of Law and the Faculty of Medicine of the University of Colombo, and also in the Department of Law of University of Peradeniya. He is also a lecturer and an examiner of the Arbitration Center of Kandy on commercial and construction arbitration law. Mr. Aberratna is also the chairman of the Communication, Data Protection and Technology Law Committees of Law Asia, the Arbitration Center of Kandy, affiliated to the Chamber of Commerce of the Central Province, the Institute of Legal and Management Studies in Sri Lanka, and the ICT Lawyers Guild of Sri Lanka. He has been appointed as a researcher of China South Asia Law Research Center, Yunnan University, Kunming. Mr. Aberratna was the secretary of the Bar Association of Sri Lanka from the year 2006 to 2008, and he served as a member of the Incorporated Council of Legal Education in Sri Lanka and Board of Governors of the National Arbitration Center. Our next speaker for the day is Mr. Jayanta Fernando, attorney at law. Mr. Fernando has over 20 years experience in international and Southeast Asian experience in a range of ICT, legal and policy issues. He was one of the first to obtain a specialized master's degree in telecommunications, ICT and internet law. He was a founder director of Sri Lanka CERT and served as its chairman. And Mr. Fernando is currently the chairman of the Sri Lanka Domain Name Registry and director of the Colombo Stock Exchange. He is also the general counsel of ICTA, and he developed the legal framework for use of authentication technologies for digital payments. And he presently chairs the Data Protection Drafting Committee as well as the Cybersecurity Law Committee. In recognition of 20 years of service in the sphere of digital policy and laws, Mr. Fernando was presented a Lifetime Achievement Award at the National 01 Digital Awards in 2017. The moderator for the day is Ms. Sanduni Vikramasinghe, attorney at law. She holds an LLB from the University of Colombo and a Bachelor of Science in Information Technology from Middlesex University, and her LLM in Law and Digital Technologies was obtained from Leiden University. After serving at one of the leading mobile telecom companies, she currently works as an independent consultant specialized in digital technology laws. She is also a certified information privacy professional and a certified information privacy manager serving as a member of the Personal Data Protection Drafting Committee of Sri Lanka. Members joining the session from Zoom may send their questions through the Q&A chat box to reach the moderator. And now I will hand over the proceedings to the moderator. Over to you, Ms. Vikramasinghe.
Thanks, Pasidini. So good evening to everyone. And so over the years, technology has continued to play a major role in shaping our society. The way we communicate with each other and the way we conduct our business transactions and obtain services from the government has considerably changed over the last 20 years. But the technology evolution is unstoppable. Laws are expected to transform or adapt to meet these changes. And therefore, transacting through electronic means have become commonplace, not only in Sri Lanka, but globally. And the pandemic has forced many of us to revisit the way we work, the way we govern, and the way we interact with each other by embracing electronic and technological means of communication, just like what we are doing today. So in the age where digital government, artificial intelligence, Internet of Things, blockchain, for example, are gaining momentum on a daily basis, it is necessary that we remain mindful of the legal implications of these developments, whilst emphasizing on the need to keep the law technology agnostic. So to that end, today, we will be devoting this discussion to speak about electronic transactions and the law that applies in Sri Lanka in the present context, and the contemporary triumphs and challenges this legal framework has faced. So to this end, the discussion will primarily focus on Electronic Transactions Act number 19 of 2006, as amended by Act number 25 of 2017, and the Evidence Special Provisions Act number 14 of 1995, and its application to electronic transactions in Sri Lanka. So without any further ado, to start this discussion, I would like to turn to Honorable Justice Chitraseri and invite him to share some background to the topic of law related electronic transactions and what it means in the legal system today. Over to you, sir. think you're on mute, sir.
Thank you very much. Good evening to everybody. I don't need to stress the importance of the development in technology, especially with regard to the justice system in Sri Lanka. And the implementation of the law will have to keep pace with that development taking place in the area of technology. So before it is better to have a idea how it was developed gradually when it comes to the justice system in Sri Lanka. Basically, in early days, it was only the evidence ordinance that was applicable when it comes to the admissibility of evidence, evidence generated by any means. The question arose at the very beginning when, in the case of Benmal versus Republic of Sri Lanka, where computer sheets where some evidence on computer sheets were made. They were trying to produce the computer sheets as evidence. Then Justice Colin Thome, in that matter, said in the evidence ordinance, there is no provision for us to admit such an evidence. That evidence is neither oral nor documentary. So, therefore, he refused to admit the said evidence. He further said the computer evidence is not admissible under any section of the evidence ordinance, and he said certainly not under section 34, where the entries in books of accounts is admissible. So thereafter, so there was a clear prohibition to admit such evidence generated through technological devices. But thereafter, even without any amendment to the law, there were decisions where the recordings of the speeches made in public were admitted in evidence. In the case of S.A. Wickramasinghe and them, the court accepted that evidence, where the recording of that speech, even though there was no, even though that the Benmal decision had been the law at that in that period. So that problem is there. Thereafter, the evidence Special Provisions Act number 14 of 1995 was enacted, and in that the computer evidence was recognized, and to various procedural methods, it was the access enacted and given the recognition to admit evidence generated electronically. then there even though that piece of enactment was enacted, there were difficulties of making use of the provisions in that due to various steps that are to be followed. Thereafter, there were so many other laws that was enacted to overcome this difficulty of admitting electronically generated evidence. In 2002, Monetary Law Amendment Act was enacted. Thereafter, Intellectual Property Act number 36 of 2003 was enacted, especially in that sections relating to software protection and protection of integrated circuits is found. Then thereafter, Local Treasury Bills Amendment Act number 1 of 2004, Registered Stocks and Securities Amendment Act number 2 of 2004, Payment and Settlement Systems Act number 28 of 2005, Money Laundering Act, then Evidence Amendment Act number 29 of 2005, Financial Transactions Reporting Act, then Payment Devices Frauds Act, Computer Crimes Act, and finally the Electronic Transactions Act number 19 of 2006 was enacted. So with the enactment of all these laws, we were able to accept electronically generated evidence. The issue here is now, how are we going? The most important enactment is the Electronic Transaction Act, where in that the object of that act enactment is to facilitate domestic and international electronic commerce by eliminating legal barriers and establishing legal certainty, and to encourage the use of reliable forms of electronic commerce, to facilitate electronic filing of documents with government, and to promote efficient delivery of government services by means of reliable forms of electronic communication, and to promote public confidence in the authenticity, integrity, and reliability of data messages, electronic documents, electronic records, or other communication. So that is those are the objects of the act. And in that act, section 3 says, no data message, electronic document, electronic record, or other communication shall be denied legal recognition, effect, validity, or enforceability on the ground that it is in electronic form. And also in section 21, it says, notwithstanding anything to the contrary in the evidence ordinance or any other written law, the following provisions of this section shall be applicable for the purpose of this act. That is, any information contained in a data message or any electronic documents, electronic record, or communication touching an effective issue or relevant fact and compiled, received or obtained during the course of any business, trade, or profession or other regularly conducted activity shall be admissible in any proceeding. So, by enacting the Electronic Transactions Act, to great extent, electronically generated evidence was could be admitted in evidence. But then the issue arose whether those provisions are applicable to other civil matters like land or divorce and other things. So this is the problem now we are facing with. But only thing is, according to the Evidence Special Provisions Act, we have to follow several steps if you are to bring in electronically generated evidence. You will have to give notice, 45 days notice before you intend to bring in that evidence. And then if the other party wants to examine the machine, you will have to allow that also. Therefore, this provision is being used very rarely. These are the problems that we are facing at the moment. Today in our discussions, we are focusing more towards the Electronic Transactions Act and its applicability towards the civil and criminal litigation. And in that, even the provisions in the Evidence Special Provisions Act also is excluded. Therefore, the steps that are to be followed in referred to in that act is not applicable when the provisions in the Electronic Transaction Act is being used. So with that, that is the history and how it is being implemented now. We can discuss further how it is being implemented when the question time is on. Yeah. So if there are any issues, then I will discuss further during the course of the question time. Right. Thank you very much.
Thank you, sir. So thank you for your input and your views on the matter at hand. And I would like to turn to Mr. Fernando, and to continue what Justice explained. I would like to seek your views on the progress and the recent policy changes in relation to the law on electronic transactions in Sri
Lanka. Good evening. Can I be heard? Yes. Your Lordship, Honorable Justice Chitrasiri, my fellow panelists, Mr. Aberratna and Sunil, and first and foremost, I would like to thank the President of the Bar Association, the Secretary and the Management Committee for the excellent job they are doing in continuing this webinar series in a very professional manner to cover subjects of significant importance of contemporary legal value. And it is in this context that this subject becomes of significant importance. Without much ado, I thought I'll quickly share some slides which I just made about half an hour ago. I hope the slides are visible. In the context of the electronic transactions law, we call it the digital transactions enabling legal framework. There are three known parties in this technology landscape. We have the government providing services to their citizens, government providing services to organizations that are paying taxes, to obtaining licenses or activities like that. These things can be done digitally. And then businesses and commercial enterprises, we all know, are engaged in their enterprise, serving their clients, and that entire cycle of activity they should be able to do seamlessly without interruption using digital means. What the Electronic Transactions Act number 19 of 2006 has done is to provide the enabling legal framework for all of these parties to do their regular business activity seamlessly in the digital media. So in that context, what I want to emphasize is that there are a couple of international standards and norms that we need to be mindful about. And the first norm that came through the work of the UNCITRAL Working Group 4 is the Model Law on Electronic Commerce, which was not a binding legal instrument, but a model law based on which countries could adopt a higher standard or a lower standard. So there were varying degrees of standards that countries adopted based on the UNCITRAL model law. That resulted in a degree of confusion, that resulted in lack of harmonization of legislation across the globe, and that became a barrier for cross-border electronic commerce, cross-border electronic trade to happen in a proactive manner. So in response to the challenges emanating from the barriers and the challenges caused by the UNCITRAL model law on electronic commerce, some years ago, the UN General Assembly passed a resolution mandating UNCITRAL Secretariat to take steps to formulate an internationally binding instrument on the subject of electronic transactions. And this became known as the United Nations Convention on the Use of Electronic Communications in International Contracts, mainly to facilitate cross-border electronic and paperless trade, and to ensure that electronic signatures are valid between countries that have ratified this international standard. And a number of new innovative online digital contracts, including automated contracts through automated messaging systems without human intervention, was recognized through this international binding instrument that became later known as the Electronic Commerce Law 2.0, or the international gold standard on the subject of digital transactions. Now, many countries are slowly but surely moving in that direction. Sri Lanka, along with China and Singapore, became one of the early adopters to signify interest in this convention. We were part of the drafting committee that drafted the convention, that was chaired by the then Singapore Solicitor General, the eminent senior counsel from Singapore, Jeffrey Chang. And drawing inspiration from this standard, a number of countries, since it's a binding legal instrument, have started work towards ratifying this instrument into domestic law. So in the pecking order, Singapore was obviously one of the first in Asia Pacific region to ratify this convention and adopt it domestic law. Sri Lanka became the second country to adopt this standard in 2015, and we amended our law in 2017 as a consequence. And then drawing inspiration from that, Fiji and many other countries in the Pacific region have adopted this standard. And now we have South Korea, Philippines, Thailand working with their domestic processes to amend the law, their electronic transactions legislation to adopt this gold standard. Australia has completed the process. Their instrument of accession is now before the Senate, and USA has been has communicated to the Senate that all 50 states have amended their domestic legislation to enable accession to the UN Electronic Communications Convention. So in Sri Lankan electronic transactions legislation, I would encourage the learned colleagues who are participating today, while you look at the Electronic Transactions Act number 19 of 2006, and while you look at the Amending Act number 25 of 2007, kindly try to download this instrument, which is in short referred to as the UN Electronic Communications Convention, and read the text and the explanatory note alongside our statutory legal framework, because we have bound ourselves through the amending act to the principles contained in this convention. So the policy framework around our Electronic Transactions Act, ladies and gentlemen, is founded on an international gold standard, and we became the, one of the early adopters of this treaty. So if you look at the long title of the Electronic Transactions Act, which was further amended in 2017, it talks of a facilitating legal environment where the formation of contracts and the creation and exchange of 4 instruments: data messages, electronic documents, electronic records, and communications in electronic form are given legal validity and enforceability and recognition. And of course, the second part in the long title after the semicolon is to deal with the administrative law framework governing the standardization for the use of electronic signatures in Sri Lanka. So basically, what I would like to flag here for simplicity's sake is to look at the definition of data messages, electronic documents, electronic transactions, electronic records, and communications, and then see for yourself how those 4 instruments is being given legal recognition through the various provisions of the law in the Electronic Transactions Act. As a result of that, we can safely say that this law would provide the enabling legal framework for all categories of electronic transactions, except for those categories which are expressly excluded under Section 23, namely power of attorneys, last wills, deeds for the transfer of immovable property, and activities like that have been excluded where notarial execution is required. So if you look at the objectives of the Act, which was further upgraded in 2017, we talk of facilitating domestic and international electronic commerce. And this objects clause was further updated, enabling the Electronic Transactions Act to be used as the instrument to facilitate filing of plain answers in courts and tribunals in Sri Lanka. So basically, in addition, of course, we have a mechanism here to facilitate electronic filing of documents in government agencies. All these activities are recognized through this legislation. What I want to emphasize here is that if you look at cases that I'm sure Mr. Aberratna will cover the electronic evidence side in greater detail. If you look at cases like Galage Piris versus Aponso, and cases similar to that, which where the in a divorce case, the admissibility of the email was not permitted to be done using the Electronic Transactions Act. I think there was a question on that in the forum a moment ago. The Civil Appellate High Court upheld an argument that the Electronic Transactions Act cannot be used for the admissibility of that particular set of emails in those divorce proceedings, because this law, as stated in the Objects Clause, facilitates electronic commerce, trade, business, and electronic government-related activity. So we can see that judicial precedents have been created, at least in the Commercial High Court, Civil Appellate High Court, where they have used the Objects Clause to define the boundaries within which Electronic Transactions Act can be used. Section 3 of the Electronic Transactions Act is very important. It provides the foundational principle that data message, electronic document, electronic record, and a communication should not be denied legal validity, enforceability, and effect purely because these instruments are in electronic form. And this section should be read together with section 21 when one looks at admitting electronic evidence, at least information that is contained in a data message, electronic document, electronic record, or other communication. The term data message, electronic document, electronic record, and communications are formulated on the basis of international standards. And I would once again repeatedly request that you look at these 4 instruments and the manner in which they are defined when you try to interpret the Electronic Transactions Act. The law contains broad features, the electronic equivalent of a writing, electronic equivalent of a signature, how they are facilitated, how electronic documents, electronic instruments can be retained, stored, archived in a manner it can be reproduced in a court or given legal validity in an arbitration or any other tribunal or any legal proceeding. And then, of course, it facilitates, it has got a separate chapter dealing with electronic contracts, and specifically there's a provision governing provision for rules governing electronic evidence, as well as facilitating admissibility of electronic documents, electronic records, or converting manual processes in government into electronic form through section 8. Section 7, I just want to emphasize that, gives legal effect to electronic signatures. This section was modified substantially through Act number 25 of 2017 to ensure a greater degree of technology neutrality. So any method used to identify a party, and as long as that method is reliable as appropriate for the purpose for which the electronic communication was generated or communicated in the light of all the circumstances, would be sufficient basis for the use of electronic signature. So therefore, ladies and gentlemen, not just even your scan signature, but a PIN number, a QR code, a biometric method of the digital signing, or a digital certificate, the more technology advanced form of electronic signature, namely a digital certificate issued by a certificate service provider, would be sufficient to gain legal validity to meet the standards of electronic signature under the Electronic Transactions Act. And in view of the fact that Sri Lanka has ratified the UN Electronic Communications Convention, electronic signature generated here would have legal validity in a country that has ratified the same UN Electronic Communications Convention. So in terms of the administrative legal framework governing the use of electronic signatures, the Chapter 4 takes care of that, which has been further upgraded. We have a certification authority that sets standards to ensure interoperability and proper governance in the use of electronic signatures even in Sri Lanka. And currently, Sri Lanka CERT performs the technical function under the supervision of a task force co-chaired by the Central Bank of Sri Lanka. After years of planning, obtaining technology, and going through a seamless, exhaustive audit process, on the Valentine's Day last year, 14th of February 2020, the Sri Lanka Root Certificate was launched. This is linked to the sectoral service providers. So one example is the Lanka Clear certification service provider, which has been in operation for a long period of time, that facilitates the entire interbank payment and settlements ecosystem. And then more recently, we have the Customs Department adopting electronic signatures, at least for their green channel customers, in relation to the digital submission of customs declarations. And many mobile providers are also moving in that direction. And of course, the latest coming from September 2020 is the digital online client registration platform that was launched by the Colombo Stock Exchange, where the client verification procedure and the digital onboarding is authenticated using a digital certificate process. And interestingly, this entire cycle in the capital markets stock exchange digitization initiative is mapped to all of the provisions of the Electronic Transactions Act, especially the provisions governing automated messaging as well as electronic contracts. And as of yesterday, we have 61,354 a new generation of investors. A majority of them are supposed to be under 35 years, who have subscribed to this application, and without even them realizing it, they are using electronic signatures every day, every hour. When they authenticate their platform with their trade pursuant to the order they make through their broker using the online digital app provided by Colombo Stock Exchange. So that is a new development I want to highlight. And of course, the subject of electronic evidence, the Chapter 5 electronic evidence rules, Honorable Justice Chitrasiri covered, as well as Mr. Aberratna would cover. I will not go into that. Only to emphasize that we have a dual regime, the Evidence Special Provisions Act on the one side, and then the Electronic Transactions Act that provides a much easier, less cumbersome admissibility regime with a rebuttable presumption. And many case law has evolved since Honorable Justice Chitrasiri gave that famous order in the Commercial High Court in the Marine Star case, admitting the information contained in an SMS sent by one of the parties in that case. So since then, we have a couple of cases in the Court of Appeal. I believe Mr. Aberratna will cover that in detail. So in conclusion, ladies and gentlemen, what I want to emphasize is that the Electronic Transactions Act provides legal certainty for digital transactions, including digital documents and electronic contracts. And Sri Lanka, having entered the gold standard, namely the UN Electronic Communications Convention, we have provided a facilitation environment where the various sectors can adopt this law to improve efficiency in the way they do the activity using digital means. Example is the capital market ecosystem that adopted this in a couple of months last year. And ever since then, through all the lockdown periods, the stock market and their activity continues without interruption since everything was mapped to the Electronic Transactions Act. And of course, the admissibility regime has to be further improved. And I believe case law will evolve and this law will be effectively used in time to come. Thank you very much, ladies and gentlemen, for a patient hearing.
Thanks a lot, Mr. Fernando, for your very valuable input in this this evening, and for your explanation about the transformation which is triggered by the provisions of the Electronic Transactions Act. So I think we have a lot to be looked forward to in this regard. So having been familiarized ourselves this evening with regards to the policy behind the existing legal framework and the progress it has made so far, I would now like to turn to Mr. Aberratna to share his views on the law relating to electronic transactions from a legal practitioner's point of view. Over to you, sir.
Thank you very much, Ms. Sanduni, and thank you very much, His Lordship, Justice Chitrasiri, my good friend, Mr. Jayanta Fernando, for elaborating on the legal reform and how this electronic transactions law came into operation in Sri Lanka. Now, as far as the Electronic Transactions Act is concerned, we can identify some specific objectives in the preamble. In addition to that, we can see that special observations and requirements and objectives under Section 3, starting from Section 3 up to Section 7, basically. Now, when we look at Electronic Transactions Act, unfortunately, our legislature has not given a clear definition for electronic transactions. The word electronic is there. Transactions, that word we have to hire from the dictionary. Then we have to give interpretation. Now, first of all, we have to find out the background of this Electronic Transactions Act, in Act number 19 of 2006. Honorable Minister who presented the bill, he has explained to the Parliament that based on UNCITRAL model law on electronic commerce and electronic signature, the Parliament has presented this Electronic Transactions Bill. But of course, as far as the provisions under Electronic Transactions Bill or Act are concerned, we can see purely that we have drafted the Electronic Transactions Act based on UNCITRAL model law on electronic commerce. But when we look at the chapters and the basic layout of the Act, we can identify 5 or 6 areas under our Electronic Transactions Act. Basically, it gives the recognition for electronic records first. Then another area is how to fulfill requirements under the Prevention of Fraud Ordinance, especially Section 18 of Prevention of Fraud Ordinance. Then electronic signature, it explains what is electronic signature. Then it explains electronic contracts and the service providers role and admissibility of evidence and other miscellaneous provisions. In addition to that, e-governance is also part of our Electronic Transactions Act. Now, as far as all these provisions are concerned, the question arises whether it is the real intention of the legislature to introduce e-commerce act or including other areas. With e-commerce act, they want to introduce this e-transactions act. So that was the confusion arise. Now, this is what Mr. Jayanta Fernando also cited, the Garlige Prabhat's case. Honorable Civil Appellate High Court Judge analyzed the situation. He went through this parliamentary debate and declared that the provisions under E-Transactions Act are applied only for electronic commerce. But unfortunately, it didn't go to the higher forum. It is only a civil appellate high court at the moment. But thereafter, a number of cases came before commercial high court. Even prior to the Galagi Prabhat's case, His Lordship, the Justice Chitrasiri, when he was the commercial high court judge, delivered the Amanda Food case, the Marine Star case. It's a landmark case, of course, I consider it as a landmark case. They recognized SMS as admissible evidence, admissible document under our law. Now, as far as this electronic transactions sector are concerned, now we can identify certain areas, number of areas, as I explained earlier. Now, basically, what we can see is when we analyze section 3, 4, 5, 6, so we can see the Act gives proper recognition for electronic records. Then again, there's a confusion is here. Even an Untitled model law, that they don't recognize 4 categories. Under our Act, we recognize 4 categories, that is data message, electronic document, electronic record, or any communication in electronic form. But most of the countries, they don't recognize all these 4 areas. They give interpretation for 1 category. Then if it is electronic record, we can see the side note of section 3 says electronic records. But under that electronic records, we have defined these 4 categories. When you come to interpretation clause, we can see some overlapping areas. So this can be a confusion anyway. You don't need to keep any confusion when you go to apply this. Of course, we have to interpret and we can produce the materials before courts. When you come to section 5 of E-Transactions Act, it says any statute needs as a requirement to maintain any document in its original form. It provides how to maintain that requirement if it is in electronic form. Now take example, it's a scan copy. Now how to recognize the scan copy under that category? Then when you look at section 6, it says if any statute, any law requires to retain any document. So how to fulfill that requirement? By way of keeping that document in electronic form. These are some additional features we can see for a document. Section 4 says the recognition of document. If the statute, if the law says the particular document must be in a written form. That is one of the requirements under section 18 of Prevention of Fraud Ordinance. So that means now our legislature has cleared the doubt, and in Sri Lanka, we can use electronic documents or electronic record as admissible record. Especially when you come to section 18 of Prevention of Fraud Ordinance, other requirement is the authentication, to recognize any document as an enforceable document. Now, how to fulfill that requirement electronically? The section 7 provides for that. All these provisions are there under Untitled model law on electronic commerce. Now, what happened was, after entering into International Convention, United Nations Convention on the use of electronic communication in international contract, we must be proud that Sri Lanka, one of the signatories, one to Asia, that we accepted this convention. After ratifying this convention, our legislature took steps to amend Electronic Transactions Act in 2006. Now, amend Act number 25 of 2017 amended certain provisions under our E-Transactions Act. Now we can see totally different section 7 authentication provision under new electronic transactions law in Sri Lanka. Now this is the basic background I want to add to Justice His Lordship Justice Chitrasiri's explanation and Mr. Jayanta Fernando's explanation. Within that framework, now we have to produce certain documents. We have to establish the position before courts. Now, when you look at section 21 is relevant to evidence. Now, when you take evidence, we know that there are two basic principles govern the evidence law: best evidence rule and rule against hearsay. Now, based on this best evidence rule and hearsay rule, the question arises how to produce evidence in electronic form before courts. On the other hand, neither in Evidence Special Provisions Act nor in E-Transactions Act, there is definition given for electronic evidence. Now, this is another issue here. What is electronic evidence? We have to give interpretation based on word electronic plus the other interpretation given for evidence. So anyway, as far as the provisions in this act are concerned, so we have to interpret what is electronic evidence. Now, Section 21 has given requirements for evidence. What is that? It says, notwithstanding anything to the contrary in the evidence ordinance or any other written law, the following provisions of this section shall be applicable for the purpose of this act. Any information contained in a data message or any electronic document, electronic record or other communication. Remember here, it explained any information contained in a data message or any electronic document, electronic record or other communication, touching any fact in issue or relevant fact, and compiled, received, or obtained during the course of any business, trade, or profession, or other regularly conducted activities. So these are the limitations for the admissibility of evidence under E-Transactions Act. We can't apply this act for any other evidence. We can't apply this act for any other evidence means there is no application of any electronic material other than materials comes under these four categories. But anyway, legislature has not limited the application of this act for electronic commerce. Now take example, it says other regularly conducted activity. If there's an electronic mail or SMS relevant to any regularly conducted activity, if that email or any SMS applied for a non-commercial matter, maybe other matters, divorce matter or other matters, or anyway, if the proponent can establish that it comes under regularly conducted activity, it's also come under this act. So we can see there is no limitation of application of the material only for electronic commerce as far as Section 21 is concerned. Now, based on this, the question arises, now how to produce this evidence? Now, when you look at Section 22, it clearly says we can't apply the provisions under Evidence Special Provisions Act for the matter comes under Electronic Transactions Act. It is a mandatory provision. Now, when you look at provisions under Evidence Special Provisions Act, it's applied for contemporaneous audiovisual evidence and computer-generated evidence. Now, how to produce this type of evidence before courts? It's explained under Section 3, Section 4, 5, 6, and 7, mainly in that act. When you look at provisions under Evidence Special Provisions Act, the law is not only substantive law, but we can see procedural law also involved in that. Section, if it is contemporaneous audiovisual evidence, the Section 4 and 4.1, 4.2 explain how to produce contemporaneous audiovisual evidence. Who has to give evidence? And what is the procedure to produce that evidence? What are the materials to produce before court under Section 6 and under Section 7? Now then Section 8 explains the presumptions and admissibility of the materials under Section 8 and 9. So when you look at Evidence Special Provisions Act, the intention of the legislature very clear to deviate the law of evidence from this original concept of the original principle of best evidence rule and rule against hearsay. During that period, most of the countries have realized If any jurisdiction strictly apply this best evidence rule and rule against hearsay, it is not easy, or sometimes it is impossible to produce evidence before courts. To avoid that, they have taken some liberalized view, especially in the United Kingdom. They amended their Police and Evidence Criminal Evidence Act, Police Evidence Criminal Evidence Act, and Civil Evidence Act twice. In addition to that, they amended that various provisions under Civil Evidence Act again, and Police and Criminal Evidence Act again, and they wanted to liberalize the admissibility of evidence more. But anyway, in the meantime, they control the mechanism applying various special provisions to their civil procedure rules and criminal procedure rules. So that is how they control the mechanism, how to collect, how to preserve, and how to produce electronic evidence before courts. Finally, they wanted to go back to the original position. Now the situation there, so still that what they say is in the UK system says, still that they want to maintain best evidence rule than rule against hearsay, rule, giving discretion to the presiding judge under the controlling mechanism of criminal procedure rules and civil procedure rules. It was followed by various countries. Even in the United States, we can see similar situation. Their federal rules are very powerful. They govern evidence rules before courts. Even in Singapore, that they have similar provisions, our e-Transactions Act. But initially, they also wanted to categorize this electronic evidence as a special type of evidence. But today, again, the concept is without modifying the original concept, principles under their law of evidence, they brought some amendment to their evidence law, keeping Electronic Transactions Act without modifying. So likewise, they have the various countries have applied various methods to accommodate electronic evidence successfully. But in Sri Lanka, there's first we have to find out what is the mechanism to produce electronic evidence before court. If there is no such mechanism, so there will be lots of practical difficulties before courts. Now we have only section 21 relevant to rules governing evidence. There it simply says it must be relevant to fact in issue or relevant fact. So they have given these are the items we can produce. Then how to produce? The act is silent. Why it is high time to regularize the procedure under Code of Criminal Procedure Act and the Civil Procedure Code, and introduce some new provisions to produce this evidence. Now take example. When you take section 4, 5, and 6, there are certain requirements. How to recognize electronic record and how to maintain the document in original form. Now how to satisfy the document in the retention of the person. And when you come to section 7, authentication. What is authentication? According to new section, that particular authentication must be in a position to identify signatory and the intention of the signatory. Both factors must be established. When we look at new section 7, we can see our legislature intention is to maintain cybersecurity. That means confidentiality, integrity, and retrievability. Then before we come to section 21, the proponent must satisfy these requirements. For that purpose, we need some mechanism. So before we come to section 21, the proponent must satisfy the requirement under section 4, 5, 6, and 7. Then only we can come to section 21. Unfortunately, that we can't see any link between section 21 and the section 5, 6, 7, and 4, 5, 6, and 7. But anyway, when we produce evidence before court, we must keep in mind. Otherwise, we might feel that it is very simple section. We can just produce this evidence before court. And the moment we produce before court, according to section 21, it says a prima facie valid evidence. It is not so. First, we have to jump all the other 4 hurdles and come to this section 21. So this is one matter that we have to look in very seriously, because we don't have any issue under Evidence Special Provisions Act. But of course, that we can apply that act for computer-generated evidence and contemporaneous audio-visual evidence. But there are the procedures there that we have to give 45 days notice prior to the trial, and likewise. And we have to give affidavit evidence. Person who knows about this device or evidence must give that affidavit, like that. There's a procedure. But here, there is no such mechanism. Now, it is high time to introduce this mechanism to pre-trial stage. Like in United Kingdom, then we must be in a position to resolve admissibility of evidence. Remember, there are 2 types of requirements. There, one is admissibility of evidence, other one is weightage of evidence. First of all, we have to establish admissibility of evidence. When the trial judge accepts the evidence as admissible evidence only, we can go to the next step. How to measure this weightage of evidence? That, of course, the party can produce this evidence, other party can challenge the weight of that evidence. Likewise, in the trial, this is what we are doing. So these are some matters that without any delay, our legislature has to look into that. In addition to that, what we can see is, when you take service providers for, but we can't identify any criminal liability of cryptography service providers under this act. This also is high time to introduce the liability. Otherwise, contractual liability is always there. But it is high time to look into that matter as well. So basically, as a practitioner, this is what I can see. This is what I have realized after doing some that research. This is what I realized. Even after 2006, unfortunately, that we don't have much decided cases before courts. Even in courts, our colleagues are reluctant to bring evidence under E-Transactions Act. One reason is, they are dark because no one knows what is the procedure and how to produce this evidence before courts. So on the tax matter, Justice Surasena, Justice Wickramasinghe, as Court of Appeal judges, they have delivered judgment. In Honorable Fernando, when he was a commercial high court judge, has delivered the judgment, admissibility, acceptance of provisions under E-Transactions Act. But in those judgment, of course, that simply that judges have declared the acceptance and admissibility of electronic records as evidence and electronic authentication. But when we come to that other areas, what I wanted to place before you, of course, we have to have some judgments and resolve these matters. So with that, of course, I will stop my this brief presentation. If you have any question, you can ask. I saw that one question raised by one of our colleagues, whether we can apply this postal rule for this electronic contracts. The issue is, of course, we can apply postal rule if there's a delay of communication. If there's a quick communication, normally we don't apply postal rule, we apply only receipt rule. But once again, when you come to cyber security and retrievability, especially when there's a DDoS attack, and under these circumstances, there are a number of judgments delivered under foreign courts, then we can't apply that receipt rule there. Under those circumstances, of course, we have to apply postal rule. To avoid this application of postal rule and receipt rule, UNCITRAL modulo on electronic commerce, even under United Nations International Electronic Contracts Convention, and even under our Electronic Transactions Act, provisions are there how to decide the time and place of the dispatch of electronic communication message, and what is the exact time and place for the receipt of that particular information. So that is how that we have resolved that issue. Then we don't need too much further on this postal rule and receipt rule because of these provisions. Yes, Sunil.
Okay, thanks a lot, Mr. Aberratna, for that very insightful description about the application of DT from a practitioner's point of view and the daily issues that you come across as a practitioner raising these issues before courts. And so we have come to the second half of our discussion for this evening. And to begin to kickstart that the second half, I would like to pose a question to Justice Chitrasiri, because there, all three panelists spoke about the application of the Electronic Transactions Act as well as the evidence special provisions. And it's often contested that there is an overlap between these two. So is it possible to draw a line as to where the Electronic Transaction Act ends and where the evidence special provisions Act begins, or vice versa?
I don't see any where you can draw a line separating the two, because electronic transactions has introduced a special regime altogether, and section 22 in that act excludes the application of the evidence special provisions act. So there is no overlapping, but especially in the ETA, they have introduced a special regime to facilitate electronic transactions, to facilitate the electronic transactions being admitted in courts and all that. So I can't say that it is overlapping, neither it's overlapping, or you can't, nor can we draw a line separating the two, but you in appropriate cases, you will have to seek the assistance of the act. But of course, as far as the Special Provisions Act is concerned, it applies across the board. So it is an act where the evidence is concerned. But in the ETA, it is not so. It is only they have introduced a special regime for a particular area. So that's what my thinking is that.
Thank you, sir. So thank you for clearing to some extent for us. And if I may turn to Mr. Fernando. So you spoke about the establishment of certification providers and the role of certification authority under the Electronic Transactions Act. Would you mind sharing more light on the role the certification providers perform, and what's the role of certification authorities under the Electronic Transactions Act?
Thank you, Sabini. Well, on the distinction between the certification authority, which is an entity recognized by and under the provisions of Section 18 of the Electronic Transactions Act, and the powers and functions of a certification authority are specified in Section 19. Maybe for clarity, if I am to simply put it, the certification authority is the administrative body that sets the standards and the rules pertaining to the governance regime that should be applicable for the business functions of a provider to operate in a manner that each provider's technology will be interoperable with each other and not in conflict. That is the entire basis and the foundation principles of a certification authority. And the concepts actually emanated from another international instrument called the UNCITRAL Model Law on Electronic Signatures, which many countries have applied domestically. On the certification service provider, CSP, I would urge participants and ladies and gentlemen to look at the definition of a certification service, where it is deemed to be a service which is provided to the sender or recipients of information in electronic form or to those storing such information, and is designed to facilitate the use of cryptographic techniques for the purpose of ascertaining ensuring the confidentiality, authenticity, and integrity of information. So basically, the concept of a certification service revolves around a provider who provides the facility for the use of a digital certificate or digital signing method, and a provider of that service is called a certification service provider, who needs to follow certain minimum standards set by the certification authority. So this is a very expensive, technologically, very, very tech-oriented area. There are a lot of security and high standards are required to be met. And that's why in any country, I would say, you can't convert everything from manual to digital overnight. It's a transformation that takes time. So gone are the days, I mean, there has to be commitment, there has to be direction, there has to be leadership, without which this won't happen. So the transformation journey in Sri Lanka, like in many countries, have taken time. So what we did was we trialed out the activities of a provider of the service, namely a certification service provider service, initially in the banking system, because banking sector was the one sector that was modernizing the fastest from 2001. So we adopted that there, trialed it out before setting the governance infrastructure that came into being later. And now, I think there was a question also on this point. Sri Lanka's root certificate is based on the Web Trust International Standard, and the Lanka Clear certification service provider is in the process of transforming their regular audit into that Web Trust standard, and both key pairs will be merged so as to enable a browser-compatible transactions with Chrome, Mozilla, and many other technologies to be used in a seamless fashion. At the moment, it is happening sectorally in the financial sector, banking sector, in the capital market sector, I explained. It's happening extremely well, and authentication is done in a manner that it leaves a footprint and a digital signature to ensure that the parties who transact in that domain are recognized. So this is the whole, putting a long story short, how the entire CSP regime works with the certification authority. It's a very difficult business because you spend millions training people and then they leave the country. Retaining people is the biggest challenge. And it's easy to criticize and say, well, this is not there, that is not there. But getting people to retain the country, to provide this kind of technology is a very difficult job. And I commend the people who have done this thus far. Thank you.
Thank you, Mr. Fernando. So moving on to my next question. So to Mr. Aberratna. So you mentioned that there is a lack of judgments where Electronic Transactions Act and electronic evidence are concerned, and this can be attributed to the inhibitions of legal practitioners who are not very conversant with these, who may not be conversant with these provisions. So this brings me to the question that, to my question, that there are certain drawbacks in adopting electronic contracts in today's society, and it can be attributed, one, to the lack of understanding of the legal principles that applies, and two, the lack of technology literacy, not just among legal practitioners, I believe, but also among the general public, So in your experience, what are the main pitfalls that one needs to avoid when forming an enforceable electronic contract? And in particular, the recognition of electronic signatures.
First, Sandhani, I will try to deal with the basic requirements for the law of contracts, how to make electronic contracts and what are the requirements. Thereafter, I will deal with other issues. Now, one objective under electronic transaction act is to recognize electronic contracts. That means under our law, we accept electronic offer and electronic acceptance. And even it applies to a counter offer as well. Now, let's come to acknowledgement of the acceptance. Now, how to acknowledge acceptance of the electronic offer? Now, we are well aware under law of contracts, the most important area is party autonomy. To avoid unwanted Can you hear me properly? Right. Now, to avoid unnecessary issues, what the parties, what they can do is, they can decide the mechanism to exchange their communication. Now, take example, offeror can say, this is my electronic offer. After accepting my offer, you have to acknowledge the electronic acceptance by way of telegram, by way of that postal letter or whatever. Then that parties can avoid unnecessary issues. Then the second, they can decide as a pre-requirement for their contract, they can decide how to decide the time of dispatch of the electronic message. So what is the exact date, time, and place, the receipt of the particular contract. Now take example, if the particular organization is closed down, therefore official work at 5 o'clock in the evening, then both
I think Aberratna has experienced some technical trouble. Just please bear with us for a moment.
I think he's in the process of connecting to another device.
this requirement and close the doors. Otherwise, we are opening floodgates for unnecessary litigation. Then it will come to consideration. Mainly through the electronic fund transferring, the people used to exchange money. That is how they pass consideration these things. Then once again, the both parties can come to various agreements. Then how to decide whether the other party receive the consideration. If there's a technical fault, that how to resolve that matter. Then of course, the other basic principles like misrepresentation and the legal contracts, that exemption clauses, all are coming under this electronic commerce as well. After, following this United Nations Convention on International Electronic Contracts, that we can see that our legislature introduced Section 11A to the under the amendment. Section 11A clearly shows how to decide whether the displaying of goods or services on the screen as an offer or invitation to treat. Now we can resolve this matter as well. Now we can see when you look at section 11, 12, 13, 14, that all these sections, all sections start with, if there is no other agreement between two parties, then apply these general provisions. So that means party autonomy is the most important, even under electronic commerce. So considering these basic principles and main areas, parties can put their preconditions into their contract. So this is one way that we can resolve lots of issues. This is one advice I can give to parties who are involved in preparation of electronic contracts. On the other hand, we must remember we had 3 eras under ICT. Even prior to 1980s, that is that man went to moon. Of course, Americans, they used computers to send rockets, even the Russia. Then we came to 1990s era. The more that we prior to 1990, this is how we use computers and printers. We use computers as basically word processors. That is the time we typed, we prepared documents and got print out. When Act number 14 of 1995 is a fit piece of legislation for that era. Now today that everything has been digitized or digitalized. Now even when you come to contemporaneous audiovisual evidence, there's a question arise whether we can apply the section 4.1 today because all are digital cameras or digital audio instruments. So these instruments are also computers. When you look at the interpretation given under E-Transactions Act, Computer Crime Act, Evidence Special Provisions Act, then the biggest challenge before us is, this is the real challenge, how to deal with metadata, data of data. Now, when you take your inbox of the documents, that we can see that exact date and time, the creation of that document. But after opening that document, even if you keep a dot and save that, then you can't see the original date and time of the creation of that document. It's a new date now. Now come back to section 5 and 6, how to maintain the original position of a document. Now, even if you produce the details of inbox before quotes, that is not the real evidence, true evidence. Then how to establish these provisions? So these are new challenges coming before legal community. So that is why that as His Lordship the Justice Chitrasiri and Mr. Jayanta Fernando very correct said, of course, this is the real challenge and this is the attempt made by legislature to step into electronic era. Now, what we can see is we are in the transit position. So we have to go a long journey. Now, this is high time to follow these other countries, how they resolve these matters and to bring either new provisions or amend or modify certain provisions, or otherwise to bring some regulation to regularize certain provisions and go ahead. Even case law also will contribute a lot for that. For that purpose, of course, judges can't write their own judges. They can't bring cases from their homes because it is the duty of our legal practitioners. But we must give the correct advice to and encourage our litigants to come before court with more and more matters. That is what His Lordship Justice Chitrasiri every time he was, I can remember he was so upset after Amanda case because the parties didn't go to Court of Appeal or Supreme Court against that judgment. Because he also had to stop that judgment that and there because he was waiting for some changes or confirmation of the judgment. But this is what happened because we also must encourage, because we are also part of this system to develop this meter. Otherwise, we will get more and more challenges in future. So we have to resolve the present situation. There's a present problem, then and there. This is what I can give this message.
Indeed, Mr. Aberratna, that's very valuable thoughts that you had just relayed. So, so speaking of electronic transactions, it is not merely in relation to commercial transactions. It covers e-government initiatives that intends to efficiently serve the public. And I would like to now turn to Justice Chitrasiri again, with the view that with the ever-increasing caseloads, which has been exacerbated with the backlogs created by the pandemic, it is natural to consider automation of judicial services. And what are your thoughts on the emerging trends globally to use automated processes, including artificial intelligence, for example, in the administration of justice?
Now, the question is, can you just repeat the question again, please?
Yes, please. So what are your thoughts on use of automation of court procedures and use of automated processes like artificial intelligence, for example, in the administration of justice?
So how do you do this? Now, I saw recently the Supreme Court has made rules with regard to the electronic filing in the Court of Appeal. So that is, and also I can say now the judges must be given proper training so that they will come to know how to tackle this situation. And the government also must take steps to enact laws and to facilitate all that to avoid other problems. So those are the areas that I can see, and also now there are so many the institutions, rather the international organization. They are prepared to help us. So we need to negotiate with them and then see how they are doing it. And especially now I can remember Mr. Jayanta Fernando was working very closely with the European Union, and he helped the judiciary here. And we had so many seminars, and by that the judges learned a lot. So those are the avenues that we can make use of. And the judges were sent out of the country, and in that program I think our judges did very well, and they were selected to train even the judges in the other countries like Nepal and all. So those are the avenues that we can think of. Judges training, new legislation, and especially, and also the lawyers, as Mr. Aberratna said, the lawyers also must be vigilant, and they must actively participate in this. Merely because they are happy with the original decision in the original court, you must have some clear decision by an appellate court, because the High Court is not just a court of record, and the decision in those courts are not bound. It's not binding over the other the lower courts. So and especially now I can remember those days when there is an appeal to the Supreme Court, especially it's only one appeal to the Supreme Court from the Commercial High Court, and then they always try to settle it. They don't argue the point. So now this young generation, they are very well aware of the rules and the development of the technology as well as the law, and you must argue and get a clear decision on these issues. And also now I see even the government institutions, they are making use of this technology to a very great extent, whereas our the development in that area is not that high. So we will have to think of those lines, areas.
Thanks a lot, Mrs. Chitrasiri. And I'd like to open up question to Mr. Fernando, who is been pioneering transformation of government, initiating e-government policies and projects. So what are your take on use of technology for the convenience of courts and administration of justice?
Thank you, Sadhuni. So to add to what Honorable Justice Chitrasiri just mentioned, what I have to say is that this digital transformation is a process. And in that journey, some sectors have been moving faster, the others are moving slower. Classic case is the leadership demonstrated by the Central Bank of Sri Lanka through the banking sector modernization project, where they initially digitized the public debt settlement systems, what we call the scripted securities trading system, with a set of norms, starting with amendments to the Monetary Law Act and with a series of amendments thereafter to the respective governing legal framework, culminating in the Payment and Settlement Systems Act, where real-time fund transfer and evidence of those transactions are maintained and permitted to be admitted as prima facie evidence. So that is a transformation. But I think in the judicial realm, it has been relatively slow, and as Honorable Justice Chitrasiri, as well as Mr. Sunil, my good friend Sunil Aberratna, all of them emphasize there's a need for training of judges. There's a need for a slow but sure pace adaptation by the legal fraternity. And I can see the young generation of lawyers wanting to function at their fingertips with their mobile devices. So what we have to provide are the tools. And in addition to the Court of Appeal rules we saw in January, the Supreme Court virtual hearing rules being gazetted, which is a welcome sign. And then under the leadership of the Judicial Service Commission, for bail applications to be filed digitally, at least in the Western Province, in the Colombo High Courts, a new set of rules were introduced. And I hope that will be spread across the country and virtual hearing becomes possible with access rights to those in remand through the virtual hearing method being extended there. So I think the journey is picking up pace. A lot of new steps have been taken. And in that light, given the point made by Sunil on the need to have due procedures, specifically enabling Section 21 to be effectively used, welcome news that we need to share is that under the leadership of Honorable Justice Fernando, there is a new effort to amend the Civil Procedure Code, where under the pre-trial procedure, discoveries, electronic evidence will be permitted to be obtained using the admissibility and the processors under the Electronic Transactions Act, as well as the ESPA. So there are a lot of new developments taking place. And in the recent times, given Sri Lanka's accession to the Budapest Cybercrime Convention, the Judicial Training Institute or Judges Institute adopted, one of the first in South Asia to adopt, an electronic evidence training manual as part of their curricula. And a whole new set of precedents have come in from that point, where several judges now function as expert trainers in the field of electronic evidence. So the transformation is happening. We are into a new phase. I hope it will happen faster so that we can keep pace with other sectors like the banking sector and the capital market sector that is providing leadership and direction in that area. And I can see in recent times the company registry also adopting such measures. Thank you.
Thanks, Mr. Fernando. So I think we have time to open the floor for questions from our audience who have been patiently waiting for the last 1.5 hours. So I will take this question from Untitled Chapter. On section 23, she explains that exempts electronic transactions in transfer of immovable property. Does this mean that in the future, electronic transactions will not apply for title registration, even though the Act requires filing of forms which can be done electronically? So I would like to pose this question to both Jayanta, Fernando, and Mr. Sunil Aberratna for your feedback.
Well, the only point I want to add is that Section 23 exclusions were brought in as temporary measures. So as and when digital adoption happens, of course, I'm not a specialist in conveyancing, so I think Mr. Aberratna can add to what I'm saying together with Honorable Justice Chitrasiri. Once the notaries get used to digital signing methods and the court and the land registry or the Registrar General becomes a CSP, certification service provider, which can issue digital certificates for each of the notaries who are wanting to do all this work electronically, I would think suitable amendments have to be brought in with regulations prescribing the mode and manner in which that activity can be done. So these exclusions, one must remember, were temporary measures that were brought in to ensure that the practices currently being adopted were not opened out for digitization immediately without proper ground rules being set. So, Sunil, if you like to add to that.
Yeah, thank you, Sandhini. Thank you, Mr. Jayanta, Fernando. Yeah, I also have to endorse the same view. Until we regularize our land registries, until we finish our digitization of land registries, we can't give these provisions. We can't open this e-Transactions Act for attesting deed of gifts or deed of transfers. I don't need to explain that you are aware that how many cases pending before district courts and high court at the moment, even under normal circumstances. So if we, at the moment, if we allow the parties to sign, place in their electronic or digital signature and to go for this attestation also in electronic form, if the land registries are not ready to accept these electronic documents, now you can see the situation. So until we fulfill all the infrastructure, until we develop this infrastructure relevant to land registries, and in the meantime, notaries must be conversant to this electronic signature or digital signature. Now, how to place this digital signature or electronic signature? There are how many notary public, including our own colleagues, know that how to place digital signature and how to, what is the mechanism of encryption and what is cryptography? Like that. First of all, we have to learn before we go for this digital attestation. So as Mr. Jayanta Fernando said, this may be a temporary provision. Temporary provision means from 2006 is temporary provision. Because after 13 years, we are discussing the same temporary provisions. It is high time to change our attitude and step into this digital era as soon as possible. This is the only way that we can overcome the situation.
And also looking at the items found in section 23, all depositions, land, the transaction with all that being excluded. So when it comes, if it is challenge, if somebody tries to bring in that evidence under Electronic Transaction Act, then the section 5 applies. Section 5 gives the discretion to court. In that, you must see the court will have to decide whether speaks about reliable assurance, whether it is reliable source. So therefore, I think it is at the moment the courts will not accept that. You will have to consider all those circumstances.
If you allow me
to,
Sandhini,
yes.
To Justice and Mr. Jayanta Fernando, that if we 100%, if we digitize this whole entire program, that they say that land registries have been digitized. Now, even no need that law. Today, what the situation? Either we have to go to land registry or reliable person must be sent to land registry and check all folios and find out whether the land is clear. Then that lawyer will come back and they consult the parties. They will attest the deed. There are instances, the seller, after selling that deed, within 1 hour or 2 hours, he will go to another office and sign another deed regarding the same property. There are lots of matters, lots of indictments also served against various accused. Now, if we have this electronic method, even litigant can see whether the proposed land to buy is clear or not. He can see the folios. He can log on to land registry and see. Then he can go to the notary public. The notary public also can go through, then he can connect all these folios with no need to go there physically. Especially due to this COVID pandemic situation, we can't go to land registry. From their office, they can find out what are the folios available in the land registry. Then and there, they can prepare the document. Then they can send the prepared document after placing digital signature. They can send that document to land registry. the land registry will register that document within a few seconds. So then another party is trying to buy the same land. Now he can see that here that person has already sold that property to another person. We can avoid lots of fraudulent activities. Only issue is, without delay, that we have to implement it. And we must learn. There is no other shortcut in future. We must learn this technology. Sometimes this is the myth our lawyers say, because technology is for computer engineers, not for lawyers. No, now it has come to legal profession. It has become a part of legal profession. We must know what is digital signature, what is electronic signature, what is encryption. It is because it is part of our law. So this is high time to learn. I can't see any other shortcut.
Yeah, so if I'm to add to what Sunil mentioned, Sunil, I really welcome what he just mentioned regarding the prevention of frauds being ensured by digital means. The latest update I have is that, the e-land registry system has been going on like a project from 2012, start, stop. But I see some activity in that direction where, although, as Honorable Justice Chitrasi said, certain classes of instruments have been excluded, the notarized documents have been excluded under 23, the registration of those notarized documents, which are governed by the Registration of Documents Ordinance, is not excluded under the Electronic Transactions Act. So there is a land registry initiative which is ongoing, and I know that at least the Colombo Land Registry and some other land registries have that system in place where the folios or related documents have been digitized, and the intention is to give user access to notaries and those who register to the system by paying a fee. You can check the entire whatever that sequence or the pedigree or whatever you call it by reference to the existing number. Now, for that to be fully functional, as Sunil said, the entire ecosystem has to be fully digitized, and that will prevent fraud. And I think some start has been made in that direction, and I call upon the BASL to maybe lobby the government to get that done faster to all land registries in the country. Thank you.
Thanks to all the panelists, because it actually brings a lot of value, and I think we kind of fringed upon the aspects of smart contracts which are being discussed in other jurisdictions. I think it's time we as practitioners and policymakers really embrace the benefits which technology can bring in to prevent frauds in this sort of matters. So I think we have time for a couple more questions. So I would pose this question in relation to, it's more of a practical concern, I think, some practitioners have. And the question is whether an agreement which is signed physically can be destroyed as long as the electronic copy of it is retained. And I will add to that, asking whether the destruction of the physical copy would have any bearing on the enforceability of such contract. I would like to pose this question to the panel, and you can briefly explain the enforceability aspects in this regard.
Sunil, can I just quickly say a few things? So if you look at section 5, the concept of originality, I mean, these are provisions founded on the principles of functional equivalence under the ancestral model law and the Electronic Communications Convention. And if you look at that functional equivalence provision, it's predicated on the premise that one does not have to maintain a paper trail. Anything that requires or where any law requires something to be, or information to be presented or retained in original form, that requirement is met when two standards, if two standards are fulfilled. So one is the availability for subsequent reference, The other one is the ability to ensure reliability with regard to the assurance as to the integrity of the information contained therein. So as long as many companies are already doing it, they are following ISO standards governing these processes, even in Sri Lanka, where they don't keep even the paper trail thereafter. And you would see even in immigration department when you go, and some other departments, they scan the original, give the original back to you, and they retain the digital record, because what they have done is a process of indexing the information as against your ID card number, let's say in the passport office, as against your new passport that is generated from your ID card number. And then they have access control procedures and information security procedures and protocols to ensure that the criteria for assessing the integrity of the information is ensured as per section 5 subsection 2A. So what I would say is that internal access control procedures, information security procedures, and other protocols in organizations have to be improved, including in the judicial system, so that as against the case number, all the records, related documents, everything that goes with it is stored in a secure manner with proper backups, so that one can ensure that it is recoverable. So if those two standards under section 5 are met, there is no need to maintain the physical copy as done in many jurisdictions. There's plenty of case law, not only from UK, but from Australia, Singapore, India, that you can rely on. And we'll be happy to provide that information if needed. But look at this as certain, look at it from a fundamental principle point of view, and you can look at the explanatory note in the Electronic Communications Convention for further guidance. Thank you.
Thank you, Mr. Fernando. And if I may just add a little that very question, because another question raised by one of our audience members is that how to ensure integrity in archive documents. So now you explained about retrievability of the aspect of retrievability of electronic documents, and the question is whether there is an accepted standard in this regard, particularly in relation to digital documents that are being archived.
Yeah, well, I'm not a specialist in archiving and those related matters, but I can safely say, yes, there are international standards. I can't remember whether there's a BSI standard or a ISO standard governing it, but archiving and storing digital information, certainly there are international standards to follow. And many international organizations, including technology companies based in Sri Lanka, are following those standards.
Yes, Anthony, in addition to Mr. Jayanta, Fernando, that I think Jayanta, issue is at the moment we don't have any regulation relevant to Section 5, relevant to integrity. So we don't need, there is no mandatory provision to follow the specific standard to establish integrity. But here, when you look at the wording, especially under amendment section, it says the time when it was first generated in its final form as a data message. So this is how that we have to establish the original position of the original document. Now take example, normally banks, they scan all our mandate. Now we physically sign and give mandate when you open bank account. Now they maintain scan copy. Even return checks also come as a scan copy. Now applying this section 5, that we can use this document as original document from the time when it was first generated. Now, question arises, then how to produce this document before courts? If we don't have this section, one can argue saying that scan copy is a secondary document. If it is secondary document, there is a way to produce primary document starting from section 61 up to section 69 of Evidence Ordinance. It explains how to produce document evidence. keeping primary evidence, you can't produce secondary evidence unless there is no permission from court. Now here to produce, if it is scanned copy is a secondary document, you can't just produce without satisfying the court, saying that the primary document is destroyed, decayed, it is in other parties' hand like that. Now we can't establish this position because the same person has destroyed. That means bank has already destroyed their primary document and produced secondary document. If we allow this to happen, we will open floodgates for corruption because people will easily destroy their primary document and bring secondary document. We can jeopardize the existing criminal justice system and other legal system. To avoid that, we can use this section 5 for electronic copy. Now here we can say this is neither document, neither primary, neither secondary. It is electronic version. When you look at this section, it says electronic version of the original document. It is applied from the time when it was first generated. And how to produce that? I think Jayanta Fernando explained that policy behind this. Of course, for the practitioners, there may be some question now, how to establish this position? Then you can call a witness from the institution. They have some internal circulars, their policy decisions, so they can produce that document. On what basis they have decided to scan and keep these copies as their original copies. So that is their policy. Without selecting that particular document, they have started to scan all documents in that institution. So they can produce that circular or policy document before courts. Then there is satisfaction. With that, they can produce that copy of the scanned copy. So that is how we have to establish the requirements under section 5.
Excellent. So I think only thing to add to that, Sunil, is that I think excellent explanation, Sunil. Thanks for that. Addition to what I said, only thing to bear in mind is, as pointed out by Honorable Justice Chitrasiri, if you look at section 21, the way it is formulated, it is actually founded on the business records exception to the hearsay rule. So there is the concept coming in 21 subsection 2b, compiled, received, or obtained during the course of any business, trade, or profession, or other regularly conducted activity is the basis for admissibility. So I think, as Sunil pointed out, that process that an entity followed would be useful. But on the point of regulation, I think, well, a regulation may be useful, but as pointed out in section 8, subsection 2, regulation is not mandatory. So what may be necessary is more awareness, education on the working method and availability of that ISO standard or whatever international standard may become recognized as part of a regularly conducted business activity if that standard is acceptable as a working practice, right? So that's the only point I want to add to what Sunil said. Thank you.
So I think.
Yeah, so the European Council introduced on 30th January 2019 electronic evidence in civil and administrative proceedings. Now it's high time to follow this, and because we can resolve lots of issues here, we invite Mr. Sari, President of the Council, and the Secretary. They all are doing wonderful service to the legal community. Please look into this matter. And in the meantime, when Jayanta and myself, we were the co-chairman of the IT committee last time, we had made a number of proposals that is published in annual report. You can go through, then you can refer this matter to new committees and go ahead. I think we can resolve lots of issues, what we discussed today.
So I would like to thank all the esteemed panelists for their valuable input today. I think we are nearing the end of tonight's session. And unfortunately, this is a topic we could talk for hours in a day, but unfortunately, we have to confine ourselves to the time frame. So again, I would like to thank the input and the feedback tendered by our esteemed panelists of this evening. And I'm grateful for input, and I'm sure our audience acquired a lot from the discussion that went on. So to conclude tonight's session, I would like to hand over the floor to Pasindini.
Thank you, Ms. Vikramasinghe. On behalf of the BASL and the Seminars Committee, I would like to thank Honorable Justice KTG, Mr. Sunil Aberratna, Attorney at Law, Mr. Jayanta Fernando, Attorney at Law, and our moderator for the day, Ms. Sanduni Vikramasinghe, Attorney at Law, for this very informative and valuable session. I would also like to thank all of you who joined us through Zoom and YouTube and for your questions that have made this webinar an interesting one. Thank you, everyone. Join us again next week on Saturday at 5:30 p.m. for the 52nd webinar in this series on a different topic. Thank you and good night.